One question, 17 words, asked at a normal speaking volume. No gavel, no raised voice, no warning. One question, and a senior official of the federal court system had his career ended before the week was out. I have been in this chair for over 30 years. I have seen money walk through that door quietly, the right firm name on the letterhead, the right number of suits arranged around the defense table. I have seen connections walk through that door, the knowing nod, the name dropped in the hallway before the session opens. But I had never, until one Tuesday morning, received a letter on official federal administrative letterhead delivered by courier to my chambers at 7:45 a.m., telling me how a case on my morning docket should be resolved before I had taken the bench. He sent it because letters like that had always worked before. He walked into my courtroom because men who send letters like that always follow them through the door. He had not met this bench before. If you believe that no letterhead, not one, not any, outranks the law this room exists to apply, subscribe and stay for every word of what happened next. I only ask once. The courier arrived at 7:45, not a standard mail delivery. A courier in a pressed shirt carrying a sealed envelope with an official federal court administrative seal on the upper left corner. He asked my clerk Margaret to sign for it and was gone before she had finished writing her name. 3 paragraphs. The first established the signatory's authority. Deputy Administrator Gerald Ashford, head of the Federal Court System's Administrative Office, an office with significant institutional reach, significant institutional weight. The second referenced the case on my morning docket by name and docket number. Specifically, the third was a recommendation, his word, not mine, framed as a professional courtesy extended from one officer of the court to another. The recommendation was that the matter be resolved without proceeding to a full hearing. I read it twice. I told Margaret to note the delivery in the record, time-stamped 7:45 a.m., contents summarized, signatory identified. Then I opened the case file. Preston Ashford, 32 years old, cited 3 weeks earlier for driving under the influence, reckless endangerment, and leaving the scene of a property damage accident. His vehicle had mounted the curb outside the Meridian Street Arts Center and destroyed an outdoor ceramics exhibition, shattering 43 hand-thrown pieces, the work of teenagers from the city's lowest-income neighborhoods, built over 4 months of Thursday evening sessions under the instruction of a 67-year-old ceramics teacher named Vera Kowalski. Vera had been present. She had tried to wave the vehicle away from the display. When it came onto the sidewalk, she moved toward the pieces rather than away from them. Her body decided before her mind did. She sustained a hairline fracture of her left wrist and severe bruising to her forearm. Preston did not stop. The man who signed that letter, Deputy Administrator Gerald Ashford, was Preston's father. When I took the bench, Ashford was already in the gallery. First row, not the second, not the middle, the first row. The row closest to the bar, the row that communicates proximity to the proceedings without technically crossing into them. 63 years old, silver-haired, a suit whose restraint was its own form of expense, a leather portfolio resting on his knee, both hands placed on top of it. His posture carried the specific uprightness of a man who has attended a great many important meetings and learned that stillness reads as authority. He was not behaving like a father. He was behaving like a senior official conducting a supervisory visit to an institution within his administrative jurisdiction. In the third row, 6 teenagers sat quietly in a line, Vera Kowalski's students. They had taken a bus across the city on a school morning, which meant they had gotten up earlier than required, asked someone for permission, and come anyway. They were watching the front of the room with the careful attention of young people who understand that what happens here this morning will matter to someone they care about. I called the first case of the morning. A young woman, 23 years old, cited for an expired vehicle registration. She explained, without being asked to justify herself, that she worked 2 jobs to cover her mother's home care costs and had not had the time or the margin to address the registration before the citation was issued. She had employment records in a folder she had prepared the night before. I dismissed the fine and waived the administrative fee. I noted for the record that this court measures its decisions against the full context of a person's circumstances. That is not a policy I apply selectively. In the first row, Gerald Ashford opened his portfolio and removed a document. Preston Ashford was next. He took his place at the defense table, with 3 attorneys arranged around him. He had the ease of someone who had been told by multiple people he trusted that this morning would be brief. His lead attorney, a man named Halsey, opened without waiting for an invitation. Minor lapse in concentration, no prior record, property damage assessed, a private remediation fund already established. The personal injury sustained by the complainant, he did not say her name, not once, was incidental to the primary incident and had been fully addressed through the same fund. He requested the charges be reduced to a single misdemeanor traffic infraction and spoke with the fluid confidence of a man billing at a rate that made the remediation fund look modest. I let him finish. Then I asked one question before he could continue. Preston Marsh had been sitting at that defense table for 11 minutes. I asked Halsey whether his client had looked at the complainant once in that time. Halsey began a response. I raised one hand and he stopped. I looked at the third row and asked Vera Kowalski if she would like to address the court. She stood slowly, her left wrist in its brace. She spoke for 4 minutes without raising her voice once. She did not speak about her pain. She spoke about Marcus, 16 years old, who had spent 6 Thursday evenings making a bowl he intended to give his grandmother. She spoke about Deja, 15, whose vase was the first thing she had ever made with her hands that she considered worth keeping. She spoke about Thomas, 17, who came every week on the bus from the East Side and had never missed a single session. She described the moment the vehicle came onto the sidewalk, what her body did, moving toward the display rather than away from it, because 4 months of a teenager's work was about to be gone. Her body decided before her mind did. She described reaching for the display and not reaching it in time. When she sat down, the 6 teenagers in the third row were completely still. That was when Gerald Ashford stood up. He did not raise his voice. Men like Ashford do not raise their voices in institutional settings because they learned long ago that volume is the instrument of people who have no other leverage. And he believed, had always believed, had been given every reason to believe, that he had a great deal of other leverage. He addressed me in the tone of a senior colleague offering a professional observation to a junior one. He noted that the administrative office had a direct interest in ensuring that proceedings of this particular nature were handled with appropriate institutional sensitivity. He noted that his office had reviewed the matter and determined that the resolution proposed by defense counsel represented a reasonable and proportionate outcome. He said it would be consistent with this court's relationship with the administrative office for the presiding judge to give the recommendation serious weight. He used that phrase twice, serious weight. The gallery was completely silent. Not the silence of people waiting to see what would happen, the silence of people who had already understood what they were watching and were holding very still because of it. I looked at Gerald Ashford across the courtroom. I did not reach for the gavel. I did not raise my voice. I did not offer him a warning, because the letter at 7:45 had already spent that warning. I asked him one question. Mr. Ashford, your letter this morning described your recommendation as a professional courtesy. I have one question. Were you extending that courtesy to this court or to your son? The gallery did not make a sound. His portfolio slid from his knee. He caught it. At the defense table, Preston Ashford looked at his father for the first time all morning, with the expression of someone who has just understood something about their own life that they cannot understand. I did not wait for Ashford to respond. There was nothing in his response that the record required. I noted for the record, at the same pace I use for every entry in this court's documentation, the letter received at 7:45 that morning, its contents, its signatory, The fact that Deputy Administrator Gerald Ashford was present in this courtroom in a personal capacity directly related to the case before the court, a fact not disclosed in the letter and not disclosed upon his arrival. I noted that the presence of a senior administrative official in a proceeding involving his own son, combined with a pre-session written recommendation regarding that proceeding's outcome, constituted on its face an attempt to leverage institutional authority for personal benefit. I transmitted a copy of the letter and the full session transcript in real time while the session remained in progress to the appropriate oversight offices. The broadcast feed, which I activate at the start of every session without exception, had been running since 9 a.m. and would be part of the public record within 24 hours. Ashford's attorney rose and said his client would be leaving. I said his client was welcome to leave. I also noted that his client's presence in the session record was already established and that the record was public documentation available in its entirety within 24 hours. Gerald Ashford closed his portfolio. He stood. He walked to the side door without looking at the defense table. His son watched him go. Preston Ashford sat at the defense table for a moment after his father left, very still, in the specific way of someone who has just had a structure removed that they did not know they were leaning on until it was gone. Then he turned to Halsey and said he wanted to address the court directly, without his attorney speaking for him. Halsey objected immediately, the practiced reflex of a defense attorney watching a client make a decision that no strategy had accounted for. He placed a hand on Preston's arm. Preston removed it, quietly, without drama, with the deliberateness of someone making a decision rather than reacting to one. He stood up. He looked at me and asked if he could speak. I told him he could. He did not look at me when he spoke. He turned to the third row, to Vera Kowalski, sitting with her wrist in its brace, 6 of her students beside her. He did not have a prepared statement. There was no legal strategy in what he said, no careful language designed to serve a sentencing outcome. He said he was sorry, not for the citation, not for the proceeding, not for the legal exposure, for the Thursday evenings, for Marcus and his grandmother's bowl, for Deja's vase, the first thing she had ever made that she considered worth keeping, for Thomas coming every week on the bus from the East Side, for the piece Vera had moved toward rather than away from and hadn't reached in time. Vera looked at him for a long moment. Then she nodded once. It was not forgiveness. It was not absolution. It was the acknowledgement that the words had been said and received by the person they were meant for. The most honest exchange that had occurred in that courtroom all morning. I delivered the sentence: 18 months of supervised probation, mandatory enrollment in a substance abuse counseling program with compliance reports submitted to this court on a 60-day cycle, 200 hours of community service, not general service assigned to a program of Preston's choosing, 200 hours at the Meridian Street Arts Center specifically, beginning with the physical work of helping Vera Kowalski's students rebuild the outdoor exhibition from scratch. Every piece, every display surface, every Thursday evening, for as long as the reconstruction required his presence. Full restitution. The destroyed pieces assessed at professional appraisal value. Vera's medical expenses covered in their entirety. And a fund administered through the city's Arts Education Office covering 3 years of operational costs for the Thursday evening program, so that Vera's students would have their Thursday evenings regardless of what else changed. Halsey did not object. Preston Ashford did not object. He signed everything placed in front of him without negotiation and without the calculated hesitation of someone still looking for what they can recover. 4 days later, Gerald Ashford resigned. The resignation statement cited personal reasons. 3 sentences. It did not mention Vera Kowalski, did not mention the Meridian Street Arts Center, did not mention Marcus or Deja or Thomas or 43 hand-thrown pieces, did not mention a woman whose body moved toward a ceramics display before her mind decided to. When investigators reviewed his tenure, what they found was worse than anyone in that courtroom had imagined. In the preceding 7 years, letters bearing Ashford's signature on official administrative letterhead had been sent to presiding judges in 5 separate proceedings involving individuals connected to his professional network. The language was nearly identical in each one. The recommendation framed as courtesy, the serious weight, the institutional sensitivity. In 3 of those 5 cases, the judges had complied. The review was ongoing. The Chief Justice issued a public statement within the week. The Administrative Office does not have the authority to recommend outcomes in individual court proceedings. Any communication suggesting otherwise does not represent the position of the court. The session transcript was downloaded more than 300,000 times in the first week. Within a month, the question, 17 words, asked at normal speaking volume, without a gavel and without a warning, was being discussed in law school classrooms across the country. 6 weeks later, something happened at the Meridian Street Arts Center on a Thursday evening. Preston Ashford arrived alone, in work clothes, carrying 43 pieces of raw clay, 1 for each piece that had been destroyed on the sidewalk outside that building. Purchased with his own money, delivered without being asked, without a court officer present to verify compliance, without anyone positioned to record the moment for purposes that might benefit him. Vera was there. Her 6 students were there. Nobody said much when he arrived. He set the clay down on the work table. He asked Vera where she wanted him to start. She showed him. He started. The program coordinator took 1 photograph and sent it to me the following morning, with no words, just the image, the time it was taken, and the address. I printed it. I keep it in my desk drawer. Some months later, I received a letter from a first-year law student who wrote that she had watched the session transcript during her first week of classes, and that the question, 17 words, no gavel, no raised voice, was the moment she decided to become a public defender rather than accept a position at the firm that had already recruited her. She asked if I had any advice. I wrote back. I told her, "Good. The bench needs people who remember what the question was. The rest you will figure out." She will. I want to say something directly to you before I close. The letter arrived at 7:45 in the morning. I had 45 minutes before the session opened. I spent them reading the case file and preparing 1 question, not in anger, not in defiance. With the same deliberateness this bench applies to every matter that comes before it, because deliberateness is not something I reserve for easy mornings. And that morning was not an easy one. Gerald Ashford sent that letter on official federal letterhead, because letters on official federal letterhead had always worked before. He had sent them before. They had worked before. In 20 years of sending them, he had been given no reason to believe this one would be any different. This bench read the letterhead. Then it read the content. Those are not the same thing. Reading the letterhead tells you who signed it. Reading the content tells you what it is asking and why. The difference between those 2 readings is not a small thing. It is the entire job, the only job. The moment a courtroom responds to the letterhead instead of the content, it stops being a courtroom. It becomes something I have spent over 30 years making sure this room never becomes. The law is either the same room for everyone who walks through that door, or it is not a room worth having. And on that Tuesday morning, 6 teenagers came across the city on a bus and sat in the 3rd row and watched it be exactly that. What stays with me, what I keep in that desk drawer, is not the question, it is not the resignation, it is not the transcript or the downloads or the law school discussions. It is a photograph of a work table on a Thursday evening, 6 teenagers, 43 pieces of raw clay, and a man in work clothes who drove away once and came back. That is what this bench is for. If this story stayed with you, share it with someone who needs to hear it today. The door is always open.